Good morning to all of you. Welcome to Legal Matters by Sai Baba Sunkara. Friends, while discussing the consumer law, already in the Act of 1986, that is Consumer Protection Act 1986, the medical service which is not free of cost. That means if the medical service, after paying the fee, if you are given the medical service, yes, it also comes under service as per the definition of Section 2LO of the Consumer Protection Act 1986. You know that the latest act, that is Consumer Protection Act 2019, also deals with the same thing. Almost here, I think Section 2, Clause 42 of the latest Consumer Protection Act also deals with the medical service, deals with the service, definition of the service. So it is, please remember, an inclusive definition. It says, but not limited to. This word is more important, please remember. Now, why this has come is, while disposing the case of Dr. Vigil and others, actually there are 7 doctors, Dr. Vigil and others versus Ambujakshi TP and another. So, 2022. You can see the citation in Live Law 2022, Kerala 107. So very recently the judgment has come. Single judge S. Nagaresh, he held that so medical service falls within the ambit of the Consumer Protection Act. Even the latest Consumer Act also deals with the medical service as a service. That means you may be knowing in Consumer Protection Act, if there is deficiency in service, you can file a case. If there is a defect in the product, we can file the case. So, deficiency of service, whether medical service comes under service as defined in Section 2, subclause 42 of 42 of the Consumer Protection Act 2019. This is the problem. Now, if you know the case law, case facts, it will be better. So, this Ambujakshi madam, she went to Dr. Vigil in Kannur. Dr. Vigil in Kannur, and the doctor stated that, madam, you have got cataract for the left eye, better you get operated. When immediately, as early as possible. Okay, she approached him, but the operation has become a failure. Then she was referred to some other eye doctors, almost Kamakshi Hospital, Jyoti Hospital or something in Kannur only. She was referred to some other hospital. Ultimately, she lost the sight of left eye. Now, she filed a case before the district forum, right? That is district CRDC, Consumer Redressal Committee. Now it is named. Previously, we used to call it the forum, simply Consumer Forum, District Forum. She filed a case. Yes, they agreed that there was a deficiency in the service, and they asked the doctors to pay an amount of 32 lakhs 52,000 or so, almost 32 lakhs 50. She has filed the complaint. Now, these people, they have raised an objection for and they wanted actually, since the the district forum has given order, they have gone to the state commission for review, but state commission in the review also, it has not agreed. It has upheld the decision or order of the district forum. So ultimately, the matter came to the High Court. So Kerala High Court. So single judge Nagaresh, he clearly held. Now the discussion of the points by justice is more important. Now we will go to, please remember the old act. Yeah, compensation of 32 lakhs 52,000, correct, right? So please remember Justice Nagaresh. So he has in detail explained the previous act, that is Section 210 of the 1996 Act, have almost the same meaning and implications as the present Section 2 subclause, Section 2 within bracket 42 of the Consumer Protection Act. So please remember, the only difference between these two acts is that Section 2 clause 42 of 2019, that is the latest act, is more descriptive, and it takes specifically the sectors like banking, insurance, financing, transport, processing, supply of electrical and energy, and telecom, boarding or lodging, or both, and housing, construction, entertainment, amusement, or purveying of the news. Of course, they did not specifically mention the medical service. This is almost on similar lines with the Old Act definition also. But what happened in the Old Act? Please remember, very famous case, Indian Medical Association versus VP Shanta and others, 1996. So there clearly Supreme Court stated that it has clearly categorized the difference between a profession and an avocation. And when you are taking money, definitely you are rendering service, whether it be medical service or not. So as a doctor, if you do free of charge, no medical negligence, and you cannot file a case under Consumer Protection Act. But when you are taking money, when you are charging fees, definitely you come under the purview of the medical service. So the famous IMA versus VP Shanta and others case, it has supported. Now the judge says that this definition is an inclusive definition. Please remember, inclusive definition. That means, that's why in the beginning I told you, but not limited to. So it is inclusive, it's not exhaustive. So many things, just like in our lot of thoughts, that Salman's theory, pigeonhole theory. Yes, if there is a new thing, it can come into the pigeonhole. So like that, yes. So please remember, basing on the very famous case of Indian Medical Association versus VP Shanta and others, 1995. You can see it on SCC 651, page number 16. So services rendered to a patient by a medical practitioner by way of consultation, diagnosis and treatment, both medical and surgical, so would fall within the ambit of service as defined under section 210 of the Consumer Protection Act 1986. Same thing. So please remember, the reading is that the definition is inclusive. So please remember, the Parliament intended, to specifically underline that services like banking, all these things, they come under the purview of services. This is, since it is an inclusive definition, so all the services which are made available to the potential users, definitely they fall under section 2 clause 2, that is within the definition of service. So please remember, this is also service and you have to pay the compensation as advised by the court. This is the judgment given by the Honorable High Court of Kerala. Right? Very good judgment. Please read it particularly. When you deal with the Consumer Protection Act, this judgment will be 100% useful to you. Right? So to conclude, I want to tell you that medical service also comes under Consumer Protection Act. Right? Thank you very much.